Hey everybody, welcome, 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 welcome to Hidden Horror. How are you guys doing? How have you been? What's been going on? How is your summer going? I hope all is well with you. So today I am here. I am here for the people. Please comment. Let me know what you think about this subject matter with Bryan Kohberger. Bryan Kohberger has filed a petition. He wants to withdraw his guilty plea. When I first heard it, I was like, wow. The reason being is because last year, right around this time, July of 2025, right before Bryan Kohberger was going to go to trial in August of 2025, he entered a guilty plea. Now, we can't go back in time, but I'm going to tell you part of my reaction to his guilty plea was he did not lay a foundation in court for what did he do with the weapons, right? Where is the bloody clothes? We don't know the why. Why did he do it, right? So I took issue with that. I want to talk about something um, that's going to relate to this, and it's going to all come together, but it's called allocution. Allocution is when a defendant goes to court and details and explains the why, the where are the clothes, where are the weapons, why did you do this, when did you do this? You're going to describe in detail. Now you should know that this is not required. Um, you can't force him to do it. It's up to him if he wants to make a statement before the court, as we're going to see, because I'm going to remind you of what happened. We're going to go back to his plea, what he said at the plea hearing, and I just did not feel it was adequate. And I was hoping that in his plea agreement that he would be forced to sit down with the law enforcement. That means the Idaho State Police, the FBI, and other law agencies and detail all of these questions, right? At the end of this video, I'm going to kind of just detail why people are so intrigued, why people are so interested. Um, it's almost as if you still don't have closure, even with the guilty plea, because people had so many questions, unanswered questions to this day. And the amount of information that's been released is so hard to go through it. I have to take time. I recently ordered or requested the autopsies for all the victims: Xana Kernodle, Ethan Chapin, Kaylee Goncalves, and I apologize if I'm pronouncing her name wrong, and Madison Mogen. But I want to go through the autopsies. I want to review them because we've been waiting some years now for the autopsies. They was done and completed in November of 2022, and it's 2026, and they're just releasing the autopsies for all the victims. So I'm very interested in the autopsies, where there are wounds, injuries. They can tell us a lot about what happened to the victims, and I believe that their deaths were very brutal. Okay, so let's go over some things. First, let's go and look at Bryan Kohberger's petition for his post conviction request to have his plea withdrawn. So I'm trying to share my screen. Um, we're going to go to the Hidden Horror Facebook page because I have that plea up, and I'm going to, as much as possible, try to enlarge it. So this is the affidavit that Bryan Kohberger he filed with the court, and he basically laid a foundation for why he feels that there is some injustice to him, and he believes, due to this injustice, that he should have his guilty plea withdrawn. And we're going to talk about different aspects of what Bryan Kohberger wrote in this petition. There's some different, things that we can kind of go over with this, and let's go from a couple of different angles. One, um, is what Bryan Kohberger is saying true? Did this happen to him? Did the things that he alleged in this petition, did this really happen to him by his counsel, which he's claiming this counsel that he received was ineffective? Now, we can remember, if we go back over, I would say about 2-3 years of the going back and forth with the motions in court, that the defense team, they filed a lot of motions. They were in court all the time. They were fighting for evidence, and entering expert witnesses, a lot of different things, right? But he's saying that the counsel that he received, it was ineffective, and we're going to talk about that. And another aspect of this is, what is Judge Hippler going to do? There's some things he can do. We do have to lay a foundation for the standard of what he can do. And it's going to be in Idaho Rule of Criminal Procedures. It's going to be in Rule 33. The section is going to be C. So we're going to talk about that. We're going to talk about, how can the defense respond? Will the defense respond? Will Ann Taylor respond to these allegations? And more so, did Bryan Kohberger file a grievance or a complaint against the defense attorneys, and specifically Ann Taylor, right? Did he file a grievance? You can do that, and we're going to talk about that process a little bit, but you can file that grievance with the Idaho State Bar Office of Bar Counsel. You can put in a complaint, and then they will do an investigation into your complaint and make a determination of what to do next, okay? So we're going to talk about that. We're going to talk about, what kind of things can Judge Hippler do? And something that we don't really focus on, but it has a big part, it plays a big part, is, have we considered Bryan Kohberger's mental health diagnoses? I'm going to talk about that a little bit, how he was diagnosed in February of 2025 prior to entering the plea in July of 2025. He was diagnosed with 4 mental health disorders, including ADHD. And we're going to talk about that. And at the end, like I said, I'm going to go over some of the things that I feel is still unanswered questions that people are grappling with. This is why people are coming back to this case 1 year later after there's been resolved. Do people believe it? I know I always think about the victims and their families and how they must feel. I know some of them wanted the trial. They wanted to keep the death penalty on the table. Some of them wanted it to be over. Now fast forward a year after the plea, and now Bryan Kohberger is now coming back saying, I was misled. I was given false information. Promises were made to me. He has an issue with his attorney client, where, his interactions and conversations and discussions and, strategy would be protected. He's saying that, most of the time, many of the times, his immediate family were included. And does that go back to his mental health? Did he have the capacity to deal with what was happening in the case? it's all just quite a bit to digest, to um, process, and I can't imagine the victim families right now. We want to always think of them and remember them and be respectful to them. And I really feel like a lot of this would not even be playing out if when Bryan Kohberger pled guilty, if it was part of his plea deal, if that was put in his plea deal to provide law enforcement, all of these agencies, the information, how did he plan these murders? Were the murders planned? Was it a targeted attack? Was one of the victims the target? We heard a lot about that in the beginning. Where is the evidence? Where did he put the evidence after the murders? Where is the clothing? Where is the weapon? Etc. How is his car so clean, right? You know, and sitting down with a defendant that pleads guilty, you can learn a lot. Um, you can try to determine if there's a pattern. I remember when I was studying things um, in the criminal justice world and certain criminals, serial killers, like a Ted Bundy, for example, there were patterns. Like he traveled, he would have blitz attacks, certain things that you could pick up and glean from the victims and the cases, and you can learn a lot. You can create a pattern for them. It would be harder for Mr. Kohberger to claim that he is innocent if he had sat down with law enforcement as part of his plea to detail all of the things that was going on with him, and how, if he planned the murders, how did he plan? Did he acquire the weapon? Did he acquire the clothing? What was his plan? Why did he pick this date, November 13th, 2022? Why did he pick the property, 1122 King Road? This would have also given closure for the victims' families if they had known some of these details. And it would be very hard for him to claim, hey, I'm innocent later on, because no, you provided us with these details. We've taken you out. We've allowed you to show us the pattern that you drove, for example. We've allowed you to show how you went through the house, how you picked the victims, how the order of the victims, etc. So you get a lot of insight into the crime, into the criminal, when you sit down with them and you have them detail the crime, the planning, and how they handled after the crime, the evidence. Okay. But that didn't happen. It didn't happen. It was not part of the plea deal. And you you cannot require a criminal, a defendant, to do this. The judge can ask questions, and Judge Hippler did. He asked Bryan Kohberger, the defendant, a lot of pointed questions, and we're going to go and I'm going to show you part of his plea. But Judge Hippler did ask him in great detail and explain his rights and what he was giving up. So it's not lawful to make a defendant allocate. And you can't put that in the plea deal. So that didn't happen in court, and then it didn't happen outside of court privately with law enforcement. Okay. So there was no real factual basis laid verbally by the defendant to the court, to the judge, that detailed the crimes. Okay. And that is the biggest problem. A lot of people are not, I don't want to say satisfied, but they still have a lot of questions lingering about the case. And of course, we know all of the things that happened in the case that was problematic. Okay. So I think when Bryan Kohberger is really alleging this ineffective counsel, in making the statements that he made in this affidavit, which we're going to go over, I think we're going to have a lot of issues with him saying things like he was convinced or he felt coerced. Um, or he felt like some evidence was withheld from him. By this case being very large, very public, in his background, he was going for his PhD. He had a background in criminal justice. Um, we have to weigh that out, and we also have to consider how much time Judge Hippler took at the plea hearing when he entered his plea, when we're considering him saying the statements that he's written in this affidavit, this petition to withdraw his plea of guilty, right? His post conviction petition. So let's look at this affidavit. Let's go through it. And it's very hard to read. Bryan Kohberger, I believe he filed this pro se meaning without an attorney. So it's not typed, it's handwritten. And I'm going to have a hard time reading this handwriting. So I'm going to enlarge it as much as I can. And I have it on the screen. I can try to enlarge it for you too, but it's very difficult to read the writing. Okay, so I've enlarged it quite a bit. So let's try to get through it. So it reads, affidavit of facts in support of post-conviction petition. Bryan C. Kohberger, being first duly sworn on oath, deposes and says, it is hereby declared that during attorney-client discussions, most of which included all members of Bryan C. Kohberger immediate family. So that's going to be a hard one because really, when a defendant is meeting with his attorney, it is one-on-one. It should be protected, whatever he says to the attorney. And most attorneys don't go outside of that. I believe that he would have to almost waive his attorney-client privilege in these discussions, conversations. He'd have to provide some type of consent for his family to be in those talks, those conversations, and those meetings, because it really should be between the defendant and the attorney. To protect the conversations, right? To protect what is said, what's discussed, strategy, planning, any type of questions or just going over the case. That should really just be between the defendant and the attorney. But Bryan Kohberger is alleging that the attorney-client discussions included his family members. Okay, so that's one piece. Okay, the next thing is petitioner was convinced to falsely confess to capital murder and felony burglary by coercion, disinformation, false promises, and the withholding of exculpatory evidence or discovery. Okay, so this is like a huge chunk. So I want to kind of like take it in smaller pieces. So the first smaller piece is Bryan Kohberger is alleging that he was convinced to falsely confess. So he is again asserting that he is innocent. I remember when the case first happened, he was saying, he's looking forward to being exonerated. But here he's saying that he was convinced, he was talked into. It was some discussions had, and they were allegedly telling him and convincing him to falsely confess to both the murder and the burglary. right? Because they kind of go hand in hand. You have to break in the house and then the murders happen, right? Um, and it was by coercion. Well, coercion is force, pressure. You should do it. You have to do it. Things like that, for example. And then he's saying it was disinformation, it was false promises. So he's saying that there were promises made to him, but they weren't true, that they did not come into fruition. Things that were said to him did not happen, okay? And then he's saying that there was withholding of exculpatory discovery. And he's saying this exculpatory means that it would tend to prove his innocence. He's saying that this information, this documentation, this evidence, it was withheld from him. It was not provided to him. He did not have counsel to really guide him and provide him with all of the evidence and more specific evidence that would prove his innocence. Okay. I mean, this is a lot. Okay. And then he's saying the following is material to the inception of the plea. So he's saying this is material, this is important information that affected my plea, right? Number one, he says, now this is when the writing gets bad. Oh boy. It looks like consent failure. I'm sorry, I'm going to try to make it as big as I can. Maybe I can make it larger on my computer screen too. That's as large as it goes. This word right here, you guys, I can't tell what it is, and I even have my glasses on. But it's failure to inform petitioner of exculpatory and, ooh, this writing is so poor, I'm sorry. Exculpatory discovery during plea discussions, possibly discussions, namely clumps of unknown hair found in Ethan Chapin's hands, as well as a failure of further inquiry. Okay, so he's saying number one, I have a problem with this. This is a exculpatory discovery that there was hair, a clump of hair found in Ethan Chapin's hands, but they didn't inquire about it. They didn't test it. They didn't find out more about it. So he's saying that this could be exculpatory discovery for him because he's saying, hey, in his mind, hey, it's not my hair. They didn't take a clump of my hair out. Mr. Chapin didn't take a clump of my hair out. It's probably the hair of the killer or killers, of course, right? So he's saying that was number one. Then he's saying number two. So I don't know how to scroll down. Can I scroll down? My apologies. Okay, well, I'm going to reduce it so you can see number two more. Okay. This is where number two starts, okay? Petitioner was, oh, I can't read it. Concerned that actual, or I'm not sure about that word, but petitioner was blank that actual guilt was not an important factor in considering plea acceptance. So is he saying, I think he's saying that no, petitioner was convinced that actual guilt was not an important factor in considering plea acceptance. So he's saying that his counsel informed him that it didn't matter if you were guilty or not. It's not important when you're considering the plea. So consider the plea because you want to take a plea. You don't want to be executed if you're found guilty. So it's not important whether you committed the crime or not. you don't want to consider that. You want to consider the plea. So this is like a bombshell to me, because part of the actions of counsel is to make sure that you're informing your client, you're providing the plea offer, and that you're advising them to be truthful, to be complete, to be honest. And if Bryan Kohberger is alleging that he was told, he was convinced that his guilt didn't matter, whether he was guilty or not, you're only going to consider the plea. It's not important whether you were guilty or not. You're considering a plea because you're saving your life. Um, and then he follows it up with death row was imminent. So basically, if you found guilty, that you're going to be put on death row and be killed. And he was advised to lie. So he's saying his counsel told him, instructed him to lie, because again, he's standing on, I'm innocent, I'm not guilty. So in order to accept the plea and say you're guilty, which they're saying it doesn't matter if you're guilty or not, you're avoiding the death penalty pretty much, you have to lie. So they told him to lie. This is what he's saying, and I'm just, trying to explain it more. And all of this is allegedly, okay? Petitioner was to gain a legal victory in entering a false plea. So maybe the legal victory is you're not going to be executed. You're not going to face the death penalty, and that's a win for you, even though you're entering into the plea and it's a lie. It's false. Okay. This is pretty bad. Number 3, a gross misrepresentation of and oh, that's bad. I'm gonna skip that word. Regarding what life sentence would immediately afford petitioner, and a gross misrepresentation of death row in Idaho, including an elaborate story of counsel's horrific experience touring an actual 8x8 section. Let me go to the page 2. Death and touring an actual death row cell, all communicated to petitioner and his family by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement. So I think what he's trying to state is when they came to him, this is allegedly, I'm just gonna, expound on it, explain a little bit more. When they came to him, they kind of described how death row would be. They gave him a story. It was horrific. The experience was really bad, and how you would be in this 8x8 cell, and this was told to his family also, and he had this tour, and he felt that these actions kind of constituted a threat to him, and that it really pushed him and induced him to enter into the plea agreement to avoid death row. Okay. Whew, that was a lot. So let me exit this because I want to go into something, I'm going to talk about the defense team, and more specifically Ann Taylor, because she was really at the forefront, but it's really covering the defense team. And something that was concerning to me when I read this petition to withdraw Bryan Kohberger's guilty plea was, um, the language, how he was convinced to confess to the murder and burglary, how he felt coerced, how he felt it was misinformation. There were false promises, how the evidence, the discovery was withheld from him. Um, these are all actions that he felt his legal counsel took towards him, really against him. And it made me wonder, and I'm going to enlarge this so we can kind of talk about it a little bit. But it made me wonder, did Bryan Kohberger take any action once he came to the understanding that this happened, um, as far as his defense team? Did he take any action to have these type of allegations investigated? So I was looking into it a little bit, and I'm believing that Bryan Kohberger doesn't have counsel right now. I'm seeing this handwritten petition for the post conviction to try to withdraw his plea. It's handwritten. It looks like he doesn't have an attorney. And I was thinking to myself, with the allegations that he made, has he looked into trying to pursue reporting, making a complaint, making a grievance against his defense team? The things that he's alleging, there's remedies, if they are found to be true. Um, there's remedies through the process of filing a complaint with the Idaho State Bar, the Office of the Bar Counsel. And I was curious, did Bryan Kohberger make a complaint against his defense team, and specifically Ann Taylor? Some of the allegations that he's making, is it possible for the attorneys to be disbarred and lose their law license? Because one of two things are happening. Either Bryan Kohberger made a false plea, he perjured himself when he said he committed the burglary, the felony burglary, and the 4 murders, or this petition is untruthful. It can't be both ways. You can't be guilty in July of 2025 and put a plea in to say you're guilty to the burglary and the murders, but then in July of 2026, you say, no, I am innocent. I felt coerced. I felt there were false promises made to me. I felt that, discovery was withheld from me. I felt that my counsel was ineffective, that they allowed these discussions, including my family members, that this was all to induce me to pressure me to enter in this plea. And you can't have it both ways. Either you were untruthful in July of 2025 with the plea, you perjured yourself by entering the plea that you knew was false, or this petition to withdraw the plea is not true. But my other question furthering it is, did you file a complaint? Did you file a grievance with the Idaho State Bar Office of Bar Counsel? Because if you felt you were coerced into the plea, you were misled, you were lied to, you were tricked, these may be grounds for a disbarment, a reprimand, etc. Okay, so I checked out the Idaho State Bar, and that's what is up now in front of you. And there's a procedure for the grievance. I'm going to read a little bit of it just so we can all be on the same page. And then there's one thing that I do want to state after I read all of it, okay? But I'll give you the skinny of it. Basically, did Bryan Kohberger file a complaint or a grievance? Because if he had, there would be an investigation. The investigation would produce an outcome. The outcome could be several things. They can just dismiss the complaint saying, you know, it's no merit to it. They couldn't find any evidence of it. They could privately discipline them if they found some things were true and supported. There could be public reprimands for things that they find to be true if they're severe enough. There could be formal charges against the attorneys if they can prove those charges, or it can go up to being disbarred by the Idaho State Bar, Office of Bar Counsel, okay? So this is what it reads, and we're just going to go through it real quick. Under Idaho Bar Commission Rule 504, Bar Counsel investigates all grievances alleging professional misconduct by Idaho attorneys. An individual who believes that an Idaho attorney has engaged in conduct that violated the Idaho rules of professional conduct may file a grievance on a form provided by Bar Counsel. Upon receipt of the written grievance, Bar Counsel will conduct an investigation to determine whether clear and convincing evidence of professional misconduct under the Idaho rules of professional conduct has been established. So my thought is, Bryan Kohberger, what evidence do you have? Were you able to take notes? Were you able to record something? Was your family, when they were involved, were they taking notes? Were they recording what was happening? What evidence do you have that this happened to you specifically, that evidence was withheld, that you were forced into the plea, that you were told to lie, that you were misled? You have to prove it, right? Because here the standard is clear and convincing evidence of professional misconduct under the Idaho rules of professional conduct. Okay? So, we're not going to read all of that. We're going to go down. And let me say this too. It says that we know the standard is clear and convincing evidence, right? They can take they can dismiss it if there's not enough evidence. If there is a violation, they can be admonished, informal admonishment. They can have a private reprimand. They may seek impose sanctions. They can be disbarred. All of that is, you know, what I said. So I was wondering, are these investigations public? And I went to the frequently asked questions, and this is what the answer is. It says, Bar Counsel's investigations of grievances is confidential by Idaho Supreme Court rule. So if there was a grievance or complaint filed by Mr. Kohberger, it would be confidential. So we wouldn't be able to publicly go and find it or call and get those records, okay? So that's just something I was thinking about. We're going to go back and discuss a little bit later about the defense team and if they're going to respond. But let's move on from that. Okay. So I'm trying to keep my notes. I have like 10 pages of notes because it's a lot to go over. So I want to go back and give you a reminder. So we're ending that. I want to give you a reminder of Bryan Kohberger's guilty plea. Okay, so all right. Okay. Give me 1 second. Share my screen. Okay. Okay, so this video is provided by Idaho News 6. It's titled Watch Entire Guilty Plea Hearing for Bryan Kohberger. So we're not going to do that. We are going to watch a few minutes. Going to start at 9 minutes, okay, in the video. And this video is basically Bryan Kohberger during the plea hearing where he pleads guilty. But I also want to highlight something that Ann Taylor did. And I said it a year ago when it happened, and it was very shocking to me, but I felt like Ann Taylor, I felt like when she answered Judge Hippler's question, which was on the lines of, did you have an opportunity to review all of the discovery? And she said yes. But if you can recall, within about a month of that plea hearing, she had been in court actually stating how much she had so much evidence. She had large evidence that was brought to her, and she had not had an opportunity to review it all. She was concerned about the trial coming up in August and that she wanted more time. And Judge Hippler, he did not want to reschedule the trial. He was very, stuck in the idea of moving forward. We're moving forward. We're moving forward. Okay. So, with that being said, we're going to hear Bryan Kohberger plead guilty to the 4 counts of murder, the 1 count of felony murder. For the 4 counts of murder, there was a life sentence for each. And for the 1 count of the felony burglary, that was a 10-year charge. He ran the charges. Sorry, I have to correct something on my writing. My e-pen's not working. He made sure that he gave Bryan Kohberger the consecutive charge. So if somehow, some way, the charges would run back to back, not concurrent, consecutive, and also all of the charges were at the max. He got the max. He got life for the 4 counts of murder, and then he got the 10-year max for the felony burglary charge. Okay. Because I want us all to be on the same page. So he received the maximum sentence for each charge. So that's important to know as we listen to this, as Bryan Kohberger pleads guilty. But again, remember, Bryan Kohberger did not allocute. He did not state a factual basis. Legally, he doesn't have to. He doesn't have to say anything. He pled guilty and nothing more is required. And it was not part of his plea deal to sit down with law enforcement and provide those details that everybody wants to know, right? Okay. And maybe it would have prevented this, right? Maybe it would have prevented Bryan Kohberger coming back later if he had did those details explaining why he did it, what he did with the evidence, the murder weapon or weapons, etc., right? Okay, so let's get started here. So we would just listen.
Defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And do you see how Attorney Taylor paused just a little bit? Because we all know, we all can remember that Ann Taylor, she was in court, she was in front of Judge Hibbler, and she said that she received a large dump of documents, of evidence, and she was unable to review it all. Now, doesn't that seem like that could possibly be grounds for ineffective counsel, right? But she stood in court in front of Judge Hibbler as he asked her, was she able to review all the necessary discovery? And she said yes, which we all know. I knew it a year ago, and I'm standing on it, that was untruthful. Now, when Judge Hibbler turns his attention to Bryan Kohberger, he's going to be very thorough, and he's going to hit on a lot of important parts, which I feel is going to make this petition, this post-conviction petition to withdraw his guilty plea, I think it's going to make it pretty hard, because Judge Hibbler is going to ask some important questions on the record, right? He's going to ask Bryan Kohberger, is he voluntarily giving his plea? Voluntarily, on your own will. And Bryan Kohberger is going to say yes. He says, I believe Judge Hibbler is going to say something like, are you pleading guilty to a crime that you didn't commit? He's going to make some kind of phrasing like that. He's also going to ask him or tell him, are your statements truthful? And Bryan Kohberger is going to say yes, right? It's going to make it harder. Again, Bryan Kohberger either lied at his plea in July of 2025, or he's not, or he's lying now in this petition, this post-conviction petition. But let's hear Judge Hibbler, how he really asks questions of Bryan Kohberger, yes or no questions, but he still puts it on the record because guess what? He will be able to stand on that he questioned him and he asked him, were you being truthful? Are you giving this plea voluntarily? Were you given any promises? Were you forced? Are you being forced to do this? He's going to ask him a lot of questions, and I think that's going to be hard on him to get out of that because he's saying, yes, I was satisfied with my attorney. No promises were made to me. I wasn't threatened to do the plea. No one told me to be untruthful. And again, either he lied at this plea hearing or he's lying now. You can't be lying in both. You can't have it both ways. So let's listen to this. And again, let's hear this testimony now. So let's go.
Have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily. And I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right. Thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not given before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated. All right. Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right. I want
to pause it right here. I always think about Bryan Kohberger's mental health diagnosis. We are going to go over them. We can insert them in here. We can do it right after this. But should there have been a question? I don't know what kind of question it would be, but I'm always thinking about that. But he did ask them, is your mind clear? Have you taken any substances? Things like that. I'm not sure, but I do think about his diagnosis is for mental health issues. Okay, let's continue.
you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled?
Let me just pause it there. So he's saying that he's not bound by the plea agreement, but the plea agreement is the maximum for each count. So Bryan Kohberger really is doing the plea agreement to avoid the death penalty, to take that off the table, because he's getting the max charge of life and plus the 10 years consecutive. So he had to be doing this to avoid the death penalty, in my opinion. Let's continue.
Guilty.
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind?
So did anyone tell you to be untruthful? He said no.
Other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
So he just said again, he's guilty. You're pleading guilty because you are guilty.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it?
So he's saying again, he's pleading guilty freely and voluntarily. Kohberger answers yes.
It's in your best interest to plead guilty.
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
So right there, are you satisfied with the advice you received from your attorney?
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
So I'm going to stop it here because I believe you got it. You can watch the entire hearing if you like, and kind of go there. But I think you got what I'm trying to show you as far as that. I want to go over an article that was shared on the Hidden Horror page. So let me pull that up. Give me 1 second. All right. Okay. So Let me get the article up. Let me get my glasses out too, because I'm going to do some reading. So this article is on NBCnews.com. There's a brief video. It's about 1 minute. So let's go do the article and then we'll do the video. The article is titled Bryan Kohberger Files a Petition to Challenge His Guilty Plea and Conviction. This article is dated July 27, 2026, and it's by Corky Samasco. And it reads as follows. Kohberger pleaded guilty last year to murdering 4 University of Idaho students and was sentenced to 4 consecutive life sentences. Bryan Kohberger, the man convicted of killing 4 University of Idaho students in 2022, is seeking to abandon his guilty plea and wants his day in court. Kohberger, who pleaded guilty in July 2025 to avoid a quadruple murder trial and is serving 4 life sentences, filed a petition for post-conviction relief Monday in the Ada County District Court in Idaho. A petition for post-conviction relief is a way to challenge a conviction outside the appeals process. The court record indicates that Kohberger is representing himself. So remember, part of the plea, he wasn't allowed to challenge everything he agreed to in the plea, his sentencing, appealing, all of that. He was agreed to not challenge anything. So this petition, this post-conviction petition, is outside of the regular appeal process, right? And it's another avenue for him to challenge the conviction. Okay, but let me get back to the article. My apologies. Kohberger, in court documents obtained by NBC News, stated that he received ineffective counsel from his defense lawyers and that he was convinced to falsely confess to a crime he says he did not commit. Kohberger wrote that he was convinced that actual guilt was not an important factor in considering the plea acceptance. He wrote that he was advised to lie and told he would gain a legal victory by entering a false plea. Kohberger's lawyers did not immediately respond Monday to requests for comment, and I'm going to talk about that, okay? The documents echo claims Kohberger made earlier in an interview with the New York Times in which he said he is innocent and had been misled into confessing to the murders. You know, I'm going to take some shots at that because of his background, his education, you know, but okay. And then we got the mental health going on. So we got all that. Okay, let's continue. My actual innocence is my truth, and the plea hinged on by false promises and blatant disinformation must be withdrawn, he said in a statement to the newspaper Sunday night, dismissing the state investigator's account of what happened as a myopic narrative and a work of fiction. Kohberger said in the statement that his faulty premises were never challenged at trial. And, you know, to be honest with that, you know, I think the prosecution after the trial, they really didn't have any evidence or a case that they could really present that I'm aware of. They stood up and did the press conferences and, you know, they say, hey, we can't place them in the house. They do have the touch of DNA, but you don't have to be in the house to have touch DNA. You don't have to have never been there. So that was very weak. And, you know, other evidence. We're not going to go over the evidence now, but Let's continue. Circumnavigated by a broken plea, the trial never provided the public the clarity conducive to closure. How about the victims' families? You know, we want them to have the closure. Okay, but anyway, and justice shall remain abjectly miscarried unless that plea is withdrawn, the statement said. Kohberger admitted last year to killing the 4 students, Madison Mogen, 21, Kaylee Goncalves, 21, Xana Kernodle, 20, and Ethan Chapin, 20, at an off-campus house on November 13th, 2022. A doctoral student in criminal justice at the time of the murders, Kohberger took a plea deal and was sentenced to 4 consecutive life sentences for 4 counts of first-degree murder and 10 years in prison for a burglary charge. While he told a judge that he broke into the off-campus house in Moscow, Idaho, and killed 4 of the 6 students there, most of them as they slept, he has never said what motivated the killings. Before the filing, Kohberger had not made any public statement suggesting he might change his plea. Idaho Attorney General Raul Labrador said his office stands ready to do whatever is necessary to ensure justice is fully carried out. My heart goes out to the families of Madison, Kaylee, Xana, and Ethan, who have already endured unimaginable loss and now must face today's deeply painful news, he posted on X. The Goncalves family referred to Kohberger in a statement as the mosquito you just can't seem to swat, and criticized the New York Times for providing him with a platform. The piece had little else to offer beyond a guilty man once again claiming he is innocent, it said. The Goncalves family said they wanted Kohberger to face trial and a possible death penalty, but Kohberger opted to plead guilty. He wants another chance to roll the dice, the family said in the statement. The defendant will get another day in court, a welcome break from solitary confinement, a ride, perhaps different food, photos taken, and the spotlight once again fixed on him and his supposed innocence. So let's watch the video that's provided. It's about 1 minute long.
Now to a stunning reversal. Convicted killer Bryan Kohberger says he wants to withdraw his guilty plea in the 2022 murder of 4 University of Idaho students. Stephanie Goss joins us now in studio. And Stephanie, he's already been convicted, so what happens now?
Yeah, so he wants to withdraw that plea and he wants to go to trial. Remember, that trial never happened. And in court documents, Kohberger says he is innocent and had ineffective counsel that advised him to lie and confess in order to avoid the death penalty in exchange for a life sentence. Legal experts we talked to say his chances of getting that trial are slim. In a hearing last summer, the judge asked Kohberger multiple times if he was guilty of killing the University of Idaho students, and he said he was. So tonight, the family of one of the victims, Kaylee Goncalves, called Kohberger the mosquito you just can't seem to swat. They also suggested, Tom, that he might be doing all of this to get back in the spotlight.
Yeah, they might have a point. Okay, Stephanie, we thank you for that.
A tax return and a tax plan are two.
Let's discuss what's coming before Judge Hippler. We have to consider the law. We talked a lot about what Bryan Kohberger put in this petition. There was no supporting documents attached that I saw, no affidavits from any witnesses or anything like that. But what does the law say? What do we look to? And let me share my screen. So we're gonna go to the Hidden Horror Facebook page. We're gonna talk about the Criminal Procedure Rule 33. Okay, and I don't know if I can make this bigger. No, I can't. Okay, well, hopefully you can see it. It's in Part C of the Idaho Rule of Criminal Procedure, Rule 33, and it talks about the withdrawal of the plea of guilty. And in this procedure, it states the following. A motion to withdraw a plea of guilty may be made only before sentence is imposed. So we know sentence has already been imposed. So it's saying that you can withdraw your plea of guilty before your sentence is imposed. And then it says, or imposition of sentence is suspended. So that's if the sentence is suspended, which it's not. But to correct manifest injustice. Okay, so to correct manifested injustice, so there's an injustice there that they want to correct, okay? The court may set aside the judgment of conviction after sentence and may permit the defendant to withdraw a plea of guilty. So there has to be injustice somewhere in there, okay, that the court wants to correct, and they can set aside after the conviction, after the sentencing, the guilty plea. So I thought more and more about it, and my whole point of showing you the video of Bryan Kohberger's plea in front of Judge John Hippler was because I wanted you to hear again how Judge Hippler questioned Bryan Kohberger, right? He asked him, did you voluntarily do this plea, enter into this plea, right? Were any promises made to you? Were you threatened to do this plea? Have you been told anything untruthful to do this plea? Were you satisfied with your counsel? All of that establishes that there's nothing to correct. There's no injustice. Even if your attorney, your counsel, or attorneys advised you to lie, to make a false plea, it's still up to you. And before the judge, you testify, you entered into the plea saying you were being truthful, that you were the killer, that you committed these crimes, that you weren't forced, right? Nobody made promises to you, and you were satisfied with your counsel, right? You testified to that. And the judge said he does not want you to plead guilty to a crime you did not commit. Is your plea voluntary? Are your statements truthful? And every time Bryan Kohberger answered in the affirmative. Yes, I'm being truthful. I'm not being threatened. I'm not being forced. And that plays into, has there been an injustice where your guilty plea needs to be set aside? So this post-conviction relief that Bryan Kohberger is seeking is because in the plea he could not appeal the sentence or the conviction. So he's going the route of this post-conviction relief through the petition. Now, Judge Hippler, he has some choices. He can flatly deny Bryan Kohberger's request. He can deny it. Okay? He can conclude that with the information that he received is insufficient on its own face value, that it really doesn't have any merit, it doesn't have any supporting documentation, and just flat out deny it, right? Or Judge Hippler could set a hearing date. Judge Hippler could give the state time to respond to Bryan Kohberger's petition. Judge Hippler could request, even require that there be more supporting documentation, additional documentation, right, from Bryan Kohberger or even the state. And the state can simply say, because all of these allegations is towards his defense attorneys, he's kind of talking about them and everything like that. Bryan Kohberger could be required to, if he has documentation provided, and the state can also respond. And I'm thinking, what could the state write? Maybe the state would say something like, due to these allegations, because they're not aware of these allegations. They're not aware of Bryan Kohberger's relationship with his attorney, and the ongoings in the conversation. So maybe they would just state that they would want some supporting documentation, and maybe they would refer to Bryan Kohberger's plea hearing where he made those responses to Judge Hippler's questions about being truthful, about if there was any threat, was he being truthful, did he commit these crimes? Also, Bryan Kohberger agreed to the state's narrative of what happened in this quadruple homicide. He agreed to it. And maybe those are things that the state would want to put on the record if they were to respond. Now, I feel with Bryan Kohberger's defense team and Taylor, the other attorneys, I feel that they should really wait to see what Judge Hippler is going to do. I don't think they should really act because Bryan Kohberger kind of opened up his attorney-client relationship when he filed the petition and made the allegations. He's kind of waived it in a sense. So maybe Judge Hippler would want to hear from the defense. I'm not sure. But I think what it comes down to, did Bryan Kohberger's rights get violated? And is withdrawing the plea the correct remedy? Again, it states that they are wanting to correct an injustice. That's what Rule 33, Part C says in the Idaho Rule of Criminal Procedure. They are looking to correct an injustice. And one of the remedies would be allowing the defendant to withdraw the guilty plea, okay? So we talked about that. Now, there's a few more things I want to go over. I think that Judge Hippler could kind of highlight a few things. If he denies the petition, Bryan Kohberger could always take it to the Idaho Supreme Court and then, of course, the federal Supreme Court. But Judge Hippler may notate a few things. He may say, well, Bryan Kohberger, you signed the plea agreement. You also agree with the narrative that the prosecution put on. You admitted to committing these crimes of burglary and the quadruple murders. You said on the record, by you answering in the affirmative to all of the questions, you said on the record that you did these crimes, that you were being truthful, you weren't being forced. And I think we also have to look at when judges make rulings, it can have an impact and set a precedent for other cases. And what if other defendants want to now challenge their conviction, because remember, plea agreements, most cases are resolved by plea agreements. It's usually over 90-95%. So what if you have more defendants wanting to take back their plea and say, well, now I want to take it back? This happened in Bryan Kohberger's case. His plea agreement was it was withdrawn, and I want to try to get mine withdrawn too. And I'm going to go the route of this post-conviction petition. And I think that's why it's important to hear that testimony at the plea hearing of Judge Hippler questioning Bryan Kohberger, because he kind of made it ironclad with the plea by going over the elements and making sure that he was satisfied with his counsel, that he was being truthful. And again, either Bryan Kohberger lied in July of 2025 at his plea hearing, or this petition is untruthful. It can't be both ways, right? So let's move on from that. We have to consider, we have to think about, was Bryan Kohberger lied to? Was he lied to? Was he coerced? Was he experiencing ineffective counsel? Were there errors? Was Bryan Kohberger misled? Was all his constitutional protections provided to him? We have to think about that. We have to consider and looking at everything involving him. And I think we also have to remember and consider that Bryan Kohberger in February of 2025, let me share my screen, he was diagnosed with 4 mental health disorders. So let me show you the documentation for that. So of course, on the Hidden Horror Facebook page, a lot of information is on there. And one thing that Bryan Kohberger had to do, he had to do a questionnaire regarding his ability to enter into the plea agreement. And he answered a lot of questions. And one of the questions he was asked was, have you ever been diagnosed with a mental health disorder? And his answer was yes. And then he listed his 4 mental health disorders, which he was diagnosed in February of 2025. He also listed the medication that he was taking. So I want to go over the mental health disorders. I didn't post this on the Hidden Horror Facebook page. This was just something that I wanted to have so I could kind of highlight it. So let me pull up, I want to pull up some information. I believe I shared it on here. I have this article by People, and they did a really good job kind of going over what was going on with Bryan Kohberger and the disorder. So I want to go over this, and then I'm going to read the article to you. So I apologize for that video being right there. So Bryan Kohberger, he was diagnosed with 4 mental health disorders in February of 2025. He was diagnosed with autism level 1, obsessive compulsive disorder, also known as OCD. My apologies for that. Try to pull it up. So, I can't get away with it. I can't get away from it. Okay, I can close it here. Okay, and let me see if I can enlarge it too. Okay. So he was diagnosed with autism level 1, the OCD, the obsessive compulsive disorder. He was diagnosed with attention deficit hyperactivity disorder, that's the ADHD, and also avoidant restrictive food intake disorder, which is the ARFID. And this was, of course, prior to him entering the guilty plea in July of 2025 for the burglary and the murders. Okay. So I just want to cover this a little bit more, and then we'll go to the article. So the autism that Bryan Kohberger was experiencing, he was diagnosed, but it affects his social interaction and behavior. So I know you guys can remember a long time ago when Bryan Kohberger was arrested and everything, and they was always talking about his social skills and how he had the eyes that would stare you down, things like that. So the autism could manifest in his behaviors. Okay, now the OCD can involve when you have the unwanted or intrusive thoughts and the repetitive behavior. So, for example, it was said, Bryan Kohberger would wear the plastic gloves. So that could manifest, the cleanliness and not wanting to touch things and be dirty. That's the OCD, for example. Now the ADHD, you have issues, kind of a hard time with focusing, paying attention to something. You might have some impulses or hyperactivity with the ADHD. And then the last one that he was diagnosed with, that was the avoidant restrictive food intake disorder. And that was basically individuals, they'll have issues with the food that they take in, the food that they consume, and the types of food. They may have a lot of restrictions and limits involving food. So he had that issue as well. So that leads me to the article by People. And let me pull it up here so I can easily read it. Okay. We're almost done. A few more minutes. And thank you for spending this time with me. The article is dated September 3rd, 2025. It's by Chris Spargo and it's titled Bryan Kohberger Diagnosed with 4 Mental Health Disorders. He reveals in handwritten guilty plea. Bryan Kohberger wrote that he received all 4 diagnoses in February of 2025, just a few months before he entered a guilty plea. Bryan Kohberger revealed that he was diagnosed with 4 mental disorders just a few months before he confessed to killing 4 University of Idaho students in a June court filing, obtained by People. Kohberger wrote that he was diagnosed with autism level 1, OCD, ADHD, and ARFID. Okay. All 4 diagnoses were made in February of 2025, Kohberger wrote. He also noted in the same document that he was taking just 1 prescription medication at the time, levothyroxine, which is used to treat hyperthyroidism and is one of America's most prescribed prescriptions. Individuals with autism level 1 are high functioning, display only a few symptoms of the disorder, and often require no assistance to perform everyday tasks. OCD is obsessive compulsive disorder, which is typically characterized by an individual engaging in repetitive behaviors in an attempt to shut out unwanted thoughts. Attention deficit hyperactivity disorder, or ADHD, is a developmental disorder that can manifest in a number of ways which vary from person to person. A majority of those diagnosed struggle to pay attention while others struggle to stay organized, keep a schedule, or stay focused on a specific task. The fourth diagnosis Kohberger received was for the eating disorder, ARFID, which is an acronym for avoidant restrictive food intake disorder. Most common in children, this disorder manifests in highly selective eating habits that greatly limit an individual's diet and can result in malnutrition and limit a person's physical growth. Kohberger did not try and claim he was not of sound mind because of any of these four diagnoses as it pertained to entering his guilty plea to the 4 charges of murder. He also wrote in the filing that he was aware of the fact that if the judge accepted his plea, he would likely be sentenced to serve 4 lifetimes in prison, along with an additional 10 years on a burglary charge. The filing was dated June 29th, just days before he formally entered his plea in court. On July 2nd, Kohberger appeared in court and confessed to killing the 4 University of Idaho students, Madison Mogen, 21, Kaylee Goncalves, 21, Xana Kernodle, 20, and Ethan Chapin, 20. 3 weeks later, he was back in court where he was sentenced to serve 4 lifetimes in prison for those murders. Okay, so the reason that I wanted to kind of talk about Bryan Kohberger's mental health is because I am concerned that when Bryan Kohberger was going through the criminal process, it was not considered. And I'm wondering if that could have had an impact on the end result of Bryan Kohberger pleading guilty, being misled as he's alleging, being able to convince to even plead guilty, and for someone to be able to say that, you basically not being guilty is not an important factor in pleading guilty. Does that have an impact on him? It's hard because we know that Bryan Kohberger, he was educated, he was pursuing his PhD, he had a background in criminal procedure, but was that applied? Some people, and I'm not saying this is him, but I'm just saying some people have not applied the knowledge yet. They haven't worked in the field. They have not gained the experience to be able to apply some of the information, education that they received to obtain those degrees, right? So I really want to just take a moment to kind of kick it in a way where, I feel the things that's going on with Bryan Kohberger, the reason that they are so relevant, the reason that, we have so many issues with the case, having so many unanswered questions, because it's a lot of things that are lingering, that are not resolved. And people wanted to see that trial. They wanted to see the evidence. They wanted to hear the testimony. They wanted to see the maps and the cell phone towers and the evidence and video and the witnesses testify. They wanted to really engage into this case, which was being investigated for more than 2-3 years at the time when the plea happened. So these are some of the things that I feel are still out there that, I just did 10 quick things, to leave the video with, things that we can think about. And, you let me know of some of the things that you're concerned about, questions that you have. I like to know. So number one, the timeline of the murder. What's the timeline? It had been changed, and people have all kind of ideas about the timeline. Number two, were there multiple weapons used? I'm gonna try to figure this out a little bit better. If I'm able to obtain the autopsy reports, I should be able to obtain the autopsy reports. I requested them, and I'm trying to find them on my own. So I'm working on that to review that, as well as it's so many documents to review, right? Number 3, all of the unknown male DNA. Was that male DNA processed? Who did it belong to? There was a bloody handprint on the hand railing. Did they find out about that? Now I'm finding out Ethan Chapin allegedly had a clump of hair in his hand. Bryan Kohberger wasn't missing any hair. So, like, who hair did that belong to? Was there any usable DNA? Were they able to use the hair to find out who that hair belonged to? Were they able to process that hair? That's another interesting one, right? The big question, and I've done a whole video on it, was where were Xana and Ethan? Where were they? When did they return home? Did they return home? I remember seeing a video of Xana and Ethan getting out of a car with a few other friends and going into those apartments. They call them the Lights, that night of the murder. And again, that's been washed. I haven't been able to find that video, but I did see that video. And I don't know what happened to that video, as well as, I've said about 2 other times, the video of Kaylee Goncalves allegedly being murdered by law enforcement, by police. I did see that video, and that video's been gone for like 2 years. I tried everything to get that video, but they've been taking them down. So anyway, let's continue. Number 5, as I've said before, Bryan Kohberger, he didn't have any defensive wounds. They have that picture of him, that selfie with the blue shirt. He didn't have any scratches, abrasions. How do you commit this crime, this very brutal, vicious attack on 3 youthful women and 1 athletic man? How? With not even a scratch, not even a tear of a skin. If I just let the dog put his paws on me, his nails, and clamp down, my skin's going to be torn from just him not even trying to do that. So how do you have an attack where you have defensive wounds? The victims are violently, viciously attacked, stabbed multiple times, chest, head, body, fingers, and this person that purports to be the killer doesn't have any wounds. That is still baffling to me to this day. Anyway, number 6, there are signs that there was crime scene cleanup, that there was blood that was tried to be erased and cleaned up. So, what's going on with that? Number 7, who viciously attacked Kaylee Goncalves? Now, I have heard of things that's in the autopsy about how she had been brutally beat, tooth knocked out, things like that. I'm going to go over that when I get the autopsy, but who attacked her, and did they have a weapon, or did they use their fists? Shouldn't that person or people have some injuries? Where are the injuries from the attacker? Number 8, were they able to find any connections from Bryan Kohberger to these victims? I believe no. I believe they have never been able to connect Mr. Kohberger to any of the victims. They went to different schools. They were not the same age. They just didn't have any connection to Bryan Kohberger. Moving on, number 9, the touch DNA, which we already know. It is a piece of evidence. It's not as reliable. And of course, you never ever had to enter that house on 1122 King Road to have your DNA, that touch DNA, left there, right? It's very easy to transfer, okay? Let's move on. Number 10, the 2 surviving roommates were up. They were on their phones, and they waited approximately 8 hours to contact the police, specifically after seeing Xana Kernodle on the floor unalive with severe defensive wounds, wounds all over her head, her face, her neck. She had been stabbed multiple times in the chest. She had wounds in her back. How do you see Xana Kernodle? If the autopsy that I'm told was for Xana Kernodle, how do you see Xana Kernodle on the ground? I can only imagine, covered in blood, and you don't come to her aid, and you don't call 911. So with these types of lingering thoughts, questions, concerns, this case is going to continue to baffle, to create doubt and questions. We want answers. We want closure, and we want the truth for the 4 victims and their families. So please let me know what you think. I want to thank you for spending this time with me. I really, really appreciate it. I want you to stay safe, stay smart, stay savvy. Be well, all my friends. Take care. Bye, everybody.